Good morning, everyone. Thank you for joining us for this coronavirus COVID-19 update. I'm Kelly Stopples. I'm a member here in Miller Johnson's employment group, and I am joined by my colleague and friend, Chris Hoffman, who also is a member of our employment group. We're obviously very well aware that many companies have already shut down and implemented short-term layoffs or furloughs, given the reality of what we're dealing with Governor Whitmer's shutdown order, and also all the economic impacts of that. However, as the situation continues to develop, and especially given the most recent extension of the shutdown order last Thursday, we understand that people are probably starting to think maybe a little bit more long-term. What is the impact? What has the impact been of the shutdown? Do we really expect that we're going to be able to return to business as normal beginning of May? And I think companies are really thinking perhaps a bit long-term about the need for making some of those short-term layoffs or furloughs longer-term or even possibly permanent. So as you're considering some possible staffing changes and working through our ever-changing landscape, we thought it would make sense to talk a bit about reductions in force and kind of give you on a high level things to be thinking about as you work through that process. Next slide, please. So here's our roadmap for what we're going to be covering over the next hour or so. Some suggestions for reductions in force, internal planning, things that you should be thinking about so as to minimize your legal risk related to claims of discrimination. We're also going to be highlighting the Older Workers Benefit Protection Act and just reminding you of some of the requirements for an effective release and waiver and how those are a bit different when you're talking about a group reduction. And then finally, we're going to be spending quite a bit of time reminding people about the Worker Adjustment Retraining Notification Act. 10 years ago, we were doing a lot of work with the WARN Act and preparing notices and helping clients work through that process of running the analysis and thinking about if they're covered, when they need to give notice, and who that notice needs to go to. Obviously, with the economy being strong over the last decade, we haven't had to do a lot of work in this area, and that means, fortunately, many of our clients haven't had to either. But with the changing landscape and, again, facing the possibility that, things have rapidly changed over the last month, and what people were thinking about with furloughs or temporary layoffs a few weeks ago, that may change moving forward. So now is a good time to kind of refresh on the WARN Act, get everyone kind of up to speed and thinking about that as you continue to work through your planning process. Next slide, please. All right, so reductions in force, internal planning. Reminder as we go through this, what we're talking about this morning for how to conduct your own internal planning, this isn't legally required. I'm not getting this from a statute. These are suggestions that we have for how you can try to reduce your legal risk, really stay on track with what you're trying to accomplish through a reduction in force, and give you some framework for how to think about this and maybe how to tackle this moving forward. So these are just kind of our suggestions of how we would suggest that you consider this. So first off, one point that I would make is that you really need to consider all of your alternatives. And obviously, as I said, in many instances, people have already done furloughs, done temporary shutdowns related to that executive order, or voluntarily, or have done other sort of temporary layoffs. I would really encourage you as you're working through this process to think if there are any other ways to cut costs that you haven't already tried. So maybe salary cuts, freezing current open positions, working through your CBAs if you're a unionized employer, considering whether there could be shortened work weeks or reductions in overtime. And again, there are a couple of reasons why I would suggest that you consider that. First off, I wish I had a crystal ball. None of us know what the future is going to look like when we get through the COVID-19 crisis. But I do know that leading up to this, so many of our clients, so many businesses were having a ton of difficulty related to recruiting and retaining talent. The unemployment rate prior to COVID-19 was at record lows, and it was very, very difficult to get good employees in the door. I don't know what it's going to look like after we get through COVID, but hopefully we return to closer to regular staffing levels. So before you lay off that talent that was so hard for you to get in the door and so costly to replace, you really want to consider all of the alternatives for cutting costs as necessary. The other reason I would really encourage you to kind of work through all those alternatives relates to company culture and messaging, right? If you do reach the point where, some of those layoffs need to be permanent, we really need to do reductions to staff, the messaging around that is going to be a lot more palatable and more positive if we're able to say, hey, we considered all of these alternatives first. This is what we did to try to eliminate costs. Unfortunately, we have come to the conclusion that we do, in fact, need to reduce staff in order to get to effective operating numbers. So really consider all these alternatives before you take the step of working through that reduction in force. Next slide, please. So when we're thinking about a reduction in force, we need to be sure that all of our decisions really relate back to the reason for the reduction. So what is it that we're trying to accomplish? Do we need to have, a 15% overall reduction in staffing costs, or is it really related to a certain product line or a certain location? We want to make sure that our decision-making process is organized, that it's consistent, that it's fair, that it's documented. And we also want to make sure that we're being consistent with company culture. So kind of keep all of that in the back of your mind as we work through the process of a reduction in force. Next slide, please. All right, so we've gone through the process. We've considered other means of cutting costs. We're at a point where we really do need to make some staffing decisions. Here's some things to think about as you're preparing to do your reduction in force. What are our business needs? So when I think about that, I think about what is driving the need for the reduction. Like I said, is it an overall reduction in cost? We need to save 20% in order to keep operations afloat. Or are we dealing with a situation where perhaps there's something just related to a certain product? A customer has gone out of business or no longer has a need for our product. We don't need to produce that anymore. That means that production line A no longer really has a purpose. So we need to look at finding ways to either reallocate those people or cut that down. So again, really, what are we trying to accomplish at the end of our reduction in force? And hand in hand with that is determining who's impacted and what's affected. Are there specific facilities or specific lines that are impacted, or really is it going to be a broader reduction? Along with that, what are the functions that we need to continue and what's being eliminated? Have we determined that related to the reduction in force, there are too many individuals who are working in an administrative role, for example? Is there a way to cut costs there and reallocate people? And what do we need to continue moving forward after we get through the RIF? Finally, what you're going to want to be thinking about is selection criteria and the selection process. So for selection criteria, how are we going to choose those individuals who we will select for a reduction in force? What does that look like? What do we want to consider? And then with the selection process, mechanically, how is that going to work? How are we going to be making those decisions? Who's involved with that? What does the team look like? How are we going to involve the appropriate people so that we're making the best decisions on behalf of the organization? Next slide, please. So a reminder about selection, and we received several questions about, how do I ensure that I am not making decisions that are unlawful? How do I ensure that I'm protecting the organization in the event that after the reduction in force, employees are challenging their selection for termination or layoff and claiming that it is because of a protected category? Happy to see those questions because you're obviously thinking about the fact that we need to be sensitive to not making selections based on any protected category under federal or state law. And we've kind of outlined different protected categories for you here. These obviously aren't a surprise to anyone on the call. We're looking at things that are protected under federal and state law. So race, sex, religion, national origin, disability. In the state of Michigan, height, weight, marital status. Depending on what state you're operating in, those state characteristics could change. One thing that we also included on this slide is COVID-19. And I just want to remind people, and I am not suggesting that you should go back and change your EEO policy or go back and change your handbook. But with Executive Order 2020-36, that Governor Whitmer issued, I think it was last Thursday. I'm starting to lose track. There are so many executive orders. But with her executive order related to protections for employees who stay home because they either have symptoms of COVID-19 or are test positive, or because they are in close proximity with someone who has symptoms or who has tested positive, we cannot take adverse action against those employees for staying home. So through that executive order, she has really created this additional kind of class of employees that I'm calling sort of our COVID-19 employees. So keep that in the back of your mind too as you kind of work through your selection process. Next slide, please. And a reminder also, when we're talking about who falls within those protected categories under federal and state law, we're not just talking about the person's inherent categories, we're also talking about actions that they may have taken. So we can't select someone for a reduction in force because they've taken FMLA leave, because they've made a complaint about harassment or discrimination, because they've had workers' compensation benefits, because they have an ADEA accommodation. So all of those actions that are also protected under federal and state law. And I raise this as a reminder because this is the way that you try to avoid opening yourself up to legal risk. Being cognizant of this, being cognizant that this is the background when you're selecting individuals, being sensitive to that. There have been instances in the past where I've been helping clients work through reductions in force. And sometimes it isn't necessarily obvious at first blush that there may be one of these issues at play, but once you kind of go through the analysis, you can see it. And you need to be sensitive to that in your role as HR as you're kind of watching and double checking how the selections are being made with your employees. Next slide, please. So what can the selection be based upon? Well, really, when we're thinking about our selection criteria, we're obviously staying away from those protected categories. And what we're looking at is we're looking at things that are more objective criteria. So we're looking at things like performance. What do the individual's, last 3 annual reviews look like? Have they received written discipline? what do they have by way of job-related certification or cross-training? What's their seniority within the organization? These are the types of things that you want to be thinking about when you're determining what your selection criteria look like. You want to make sure that you're being as objective as possible with this. As a practical matter, when you're thinking about cross-training, ability to perform on different production lines and abilities, you as HR are going to need to have other people weigh in on this. The reality is that our managers and supervisors will likely have a much better handle on what people are capable of performing and who is able to cross-train or cross-perform different functions, maybe enabling them to have a bit more flexibility and be more valuable for the organization moving forward post-RIF. What I would encourage you to keep an eye out for, and this is where HR really is critical, managers and supervisors, we're all human, right? And I have seen in the past where personal preferences can come into play, not based on an objective criteria, but just, well, you know, I like this person better than this other individual. So you really want to make sure that you're considering and kind of weighing what those supervisors or managers are telling you. You may also, as you put your team together to work through the RIF process, may want to have a manager from a different area weigh in. That way you have a couple different perspectives on employees' abilities, and you're sifting out some of those more kind of subjective criteria that may not be as easily defensible if the reduction in force selection is challenged down the road. Next slide, please. All right, so the plan. As I mentioned before, sometimes it's evident what group we're talking about, right? There's a specific product line that's being eliminated. That product line and the individuals who support that product line is what we're going to be looking at when we're thinking about a reduction in force and eliminating headcount. Sometimes it may not be so obvious. For example, if we're just looking for an across-the-board cost reduction. But as you're moving through the process and you're selecting employees, it's important to identify the universe that you're choosing those employees from. Next slide, please. We talked earlier about starting to kind of think about your selection criteria. So as your team members for the reduction in force have weighed in on what you're going to be using as your criteria, you really want to finalize what that looks like. So what is our objective criteria? What have we decided upon? And here I've just given you a list of things that could be that objective criteria. So let's say that everyone has had input, you know what group it is that's going to be impacted by the reduction in force. You've got the managers who are at play, giving you their feedback on what's important for them to be able to continue to function. You as HR are there, you're involved with evaluating and helping to gather criteria. So let's say that we've landed on these. We have seniority, length of service, education, certifications, attendance, prior discipline, cross-training, and what job functions they support. As you go through and identify this criteria, you're going to want to figure out how you're going to weight it. And this is something that you get to make the determination on. So here's the criteria we're considering. What do we think is most important? You know, do we want to assign a number? So for example, let's take a look at prior discipline. If someone has gone 3 years without any discipline, then they're going to get 5 points. If they have had discipline over the last couple of years, that's going to be worth less. It'll be worth a point. However you want to weigh that, that's up to you. The important thing is that you all agree on what the objective criteria will be and that you come up with a plan for how you're going to apply this standard criteria. Because again, we want to be consistent in our approach, and we want to be as objective as possible. Once again, I would highlight that HR, one of your key roles in this process is going to be to check for possible bias. Again, people are human. It can come into play here. So you want to try to keep things as pure as possible, working with your team, weighing in on the different criteria. And some of this also, in terms of the team that you pull together and how you weight this different criteria, it's going to be business specific. So it's going to depend on your organization, what you're trying to achieve on the other end of the reduction in force, and really what's most important to you. These are examples of things that you might consider. Next slide, please. So it's really critical as you go through the reduction in force process that you do an analysis to see what the impact might be. And what we're checking for here, as I'm talking about doing a demographic analysis, is we're really looking to see what the impact might be now that we've established our criteria, what the impact might be as we apply that on our employees. And again, we're trying to identify areas where we may have some potential legal risk related to a disparate or disproportionate impact of our reduction in force criteria on certain protected classes of employees. So I would encourage you, before you move forward with your RIF, to take a look, take a snapshot, if you will, of what your workforce looks like right now. So take a look at each of your different departments and break those down by race, sex, age, and then repeat that analysis if there's a section that's going to be impacted. So you've got your overall kind of big picture numbers of what your workforce looks like, and then let's say that there's a certain production line that will be impacted. What do those statistics look like for that production line? And the reason that we're doing that is because we're kind of setting our baseline. So we take a look at our organization and we see what our percentages are. So let's say that we take a look and the group that's going to be impacted, there is 30% of that group that is female. Ideally, when we take a look at our RIF numbers and what the impact would be and what that percentage looks like post-projected RIF, it would be the same kind of percentage post-RIF. And again, the idea here is that we're trying, before we've made any final decisions, to take a look and see if there are any obvious disparities in who is being impacted by our selection criteria. Next slide, please. And again, we've done sort of our baseline analysis. Once you've made some tentative selections, you want to do that same analysis and review what that looks like post-RIF. And what I'd encourage you to do is to consider doing that with counsel so that that analysis and communications related to that analysis are confidential. If you do discover that perhaps there is a larger impact or an unexpected impact on certain groups of employees, you can certainly tweak the criteria that you're using, or at the very least, go back, take a look, make sure that you have legitimate business purposes and that those purposes are documented for the reasons that you're applying for your reduction in force. And again, what we're looking for here is something where there's a disparate impact. So by way of example, let's say that you've got a group that is only 20% female, but when you run your reduction in force numbers, 2/3 of the individuals in that group who are being selected for termination are women. Well, that number tells you that something might be a little bit off. And again, that's not to say that that reduction is illegal in and of itself, or that there's a discriminatory reason that's leading to that outcome. But that's a flag for you to go back, take a look at what that criteria is, and how that criteria is reaching the result where that unexpected higher percentage of individuals within the protected class are being selected for reduction in force. If those numbers are off and there seems to be an indicator of disparate impact, then that's a sign for you that there's a greater risk that there could be a legal challenge down the road to that reduction. Next slide, please. And again, we've been through this. So once the tentative selections are made, we want to review the reduction as a whole and take a look at the impact on these different categories. Next slide, please. All right, so communications. You've gone through the process. We've determined who's going to be selected. We've done our disparate impact analysis and feel confident and comfortable about the people who have been selected for termination or layoff. Now you need to think about how you're going to be communicating that to your employees. And again, this is where it's very helpful to have taken that first step of really crossing every possible bridge in terms of eliminating cost. And the communication to employees, I found that it's very helpful if you can say, here are the 5 things that we've already done to reduce costs. Here are all the things that we considered. Unfortunately, we're at the point where we need to eliminate positions. As you're thinking about that communication, you need to think about mechanically, what is that going to look like? How is that going to be communicated to your workforce? Are you going to have all employee meetings where there's an announcement made? What has the communications been up till that point? Who does that communication? And again, this is a culture thing, right? Is it the CEO? Is it the president? Is it the head of human resources? Who is going to be making that communication? And then how are you going to be communicating the decision to those employees who are impacted? Will you be able to have the one-on-one meetings? Is it necessary, because it's a larger pool of employees, to schedule group meetings with a variety of different managers kind of running those meetings and HR providing them with talking points? Mechanically, you need to think about what that looks like. When word of a reduction in force is either being considered or is going to be happening, starts spreading through the workforce, it spreads like wildfire. So you want to make sure that you're out in front of it and that you've thought about that with your communications. The other thing that you'll want to be thinking about related to those communications to impacted employees is having a letter prepared for them with information about benefits, with information about unemployment, any other helpful information to those employees that you can give them. And then you want to think about exiting those employees from the workforce. So we've announced it, we've told people who are impacted that they're going to be separated. What next? You know, mechanically, we need to get them out. We need to make sure that we've put something in place to either pack up their belongings and send them, or give them an opportunity to do that. And again, it's going to be fact specific depending on your specific circumstances. But think all that through before any word gets out about a possible reduction in force. The other thing to think about when you're considering communications is think about security. Is there a need to notify local law enforcement? Should private security be hired for that day or maybe a couple days after you do those communications? So again, that kind of goes down to mechanics of things to think about when you're communicating the decision. Next slide, please. And finally, just some additional things to kind of be thinking about as you work through the process. You also want to be thinking about individual employment contracts. Are there people who are not at will? They have a contract. How does that plan if they're chosen for separation? If you are a unionized facility, you need to think about your collective bargaining agreement. What does it say about bumping, about layoffs? You're going to want to be communicating with your union on that. If we're closing down specific product lines, are we concerned about effects bargaining? So it gets more complicated if you're unionized. You also want to think about your employee handbook or any other written policies. In some instances, there are policies and handbooks that I've seen that talk about a layoff procedure. You also want to think about payout of vacation pay, and again, related to the CBA. But also in some instances, I've seen this in an employee handbook where there are essentially bumping rights even for non-union employers. So you want to think about all that as you're working through this process and making sure that you've checked all those different boxes and are complying with your internal policies and procedures as well. Next slide, please. All right, the Older Workers Benefit Protection Act. We're going to go through this pretty quickly, but just a reminder, as you're working through the possibility of layoff, you may be considering wanting to get a waiver and release of claims. Related to age discrimination claims, the Older Workers Benefit Protection Act is an amendment of the Age Discrimination and Employment Act. There are specific hoops that you have to jump through in order to have an effective release of age discrimination claims. I'm not going to read them all to you, but I've outlined them here. It's a very kind of technical, nitpicky act, so do make sure that you comply with this if you're trying to get an effective age discrimination waiver. Next slide, please. Additional consideration for group reductions or group layoffs. Generally speaking, with the Older Workers Benefit Protection Act, you need to provide someone with at least 21 days to consider their waiver and 7 days to revoke. That changes a bit when you're talking about a group layoff. In that case, you have to provide 45 days to consider, and there are additional requirements related to a disclosure form that needs to be prepared and provided to employees. The disclosure form includes the decisional unit, and that's the group of employees from whom the employer chose individuals. So that group that was potentially eligible for layoff or eligible for the severance pay under the group severance. What did you consider? What were the eligibility factors? Time limits that apply to the program. And then you also need to provide a listing of the job titles and the ages of individuals who were and were not selected. And I know this is a little odd, but the reasoning behind this is it's to provide people who are within that protected category of being 40 years of age or older with information about who was selected, so they have a better handle on whether it's all people who are within that same protected category who have been selected, or if really it's a wide range of individuals. That's the idea behind that additional disclosure form. Next slide, please. And with that, I'm going to turn it over to my colleague, Chris, to go over the WARN Act.
All right, thank you, Kelly. And good morning, everybody, and thank you for joining us. So as Kelly mentioned at the get-go, we've been fortunate that we haven't really had to think about the WARN Act a whole lot over the past 10 years or so, because when economic times are good, we're not engaging in plant closings or the type of mass layoffs that trigger the notice requirements under the WARN Act. But now, obviously, with the shutdown order, many employers are either laying off workers temporarily or placing them on furlough. And so we wanted to give you guys a kind of high-level overview of the WARN Act so you can consider whether it's going to apply to your business and whether it will apply to, a layoff or furlough that you take as, part of your adjustment to this new world that we're living in. So the Worker Adjustment and Retraining Notification Act, it is a requirement that employers give laid off employees 60 days notice in advance of their layoff. And it applies when we're talking about a plant closing or a mass layoff, and those terms are defined, and we're going to go over those here shortly. So can I have the next slide, please? All right, so first off, who does the WARN Act apply to? The magic number here that we're looking at is 100 or more employees, and that is not going to include our part-time employees. And we're talking about, for part-time, those are people who work less than 20 hours in a work week. You know, usually we think about the Affordable Care Act and the 30-hour requirement there. Here we're talking about 20 hours, so just make sure that you're thinking about that distinction for purposes of the WARN Act. Excluded from employees are independent contractors. And if you are a parent company, you may be able to exclude your subsidiaries, provided that you have, you know, appropriate independence between the parent and the subsidiary. So, you know, just think about that if you're a parent company, whether or not you're going to include all of your subsidiaries depends on whether or not there's a separation of control between the entities, separation of the board of directors, those sorts of considerations. All right, can I have the next slide, please? So when we're talking about a mass layoff, this is a layoff employee that is not a plant closing. So we're talking about just a total number of layoffs at a single site that is 33% or more of the non-part-time workforce. So you could have a plant that, or a single site of employment that has 500 total employees, and if you lay off 100 of those employees, you haven't met that 33% threshold, and you're not going to trigger the WARN Act requirements with respect to a mass layoff. However, that 33% requirement does not apply if 500 or more non-part-time employees are laid off from a single site of employment. Okay, can I have the next slide? All right, a plant closing. This is when you're shutting down an entire single site of employment, or you're shutting down a unit within a single site of employment, and it results in the employment loss of 50 or more full-time employees. And here, just the important distinction with a mass layoff is that the 33% requirement doesn't apply. So anytime you shut down a unit or a department and it results in the employment loss of 50 or more full-time employees, WARN is going to be triggered regardless of whether or not that's 33% of the workforce. All right, can I have the next slide? Okay, so when we're talking about affected employees, these are employees who are terminated as a result of the layoff or the reduction in force, and it does not apply to people who are discharged for cause, people who have voluntarily departed, or who have retired. And WARN is only going to apply when the layoff is going to exceed 6 months in time. And so, you know, when the governor's shutdown order went into effect, we, you know, hopefully it's not going to exceed 6 months. If you look on the state website, you can actually see WARN notices that have been posted. And many of them, you know, will indicate that the employer doesn't anticipate that the layoff will be for 6 months or longer, and so WARN doesn't apply to the layoff, but the employer is providing the notice out of an abundance of caution. And so that's one strategy that, you know, some employers are taking is to provide the notice, even though WARN may not apply. And as the kind of shutdown gets extended, I would anticipate that more and more employers may be taking that approach. Just, you know, again, out of an abundance of caution, not knowing how long some of these layoffs may last. But under the Act, if the layoff isn't going to last more than 6 months, then technically the notice isn't required, even though the Act encourages employers to give notice even in those situations. Okay, next slide, please. So the WARN Act typically looks at a 30-day time frame, how many layoffs occurred over this 30-day window, but where there is a series of small layoffs, none of which would individually trigger the WARN notice requirements. These smaller layoffs may be combined, and in these type of kind of rolling layoff situations, we look at this 90-day window, and we determine whether or not the number of layoffs that occurred during this 90-day window met the 50 employees threshold to trigger the WARN notice requirement. So if we go to the next slide, we can see kind of an example of how that would work. So here in this example, the employer Ajax has 180 employees on day one. The next day they lay off 30 employees, and then about 30 days after that, they lay off 29 more employees. So with the first round of layoffs, having laid off only 30 employees, WARN wouldn't have been triggered at that point, but then we look out 30 more days and now we've laid off 29 additional employees. Now we've exceeded that 50 employee threshold, and as we go through this 90-day period, they lay off 11 more employees. Well, because they are in this kind of rolling layoff scenario where they've engaged in a series of smaller layoffs, none of which would ordinarily trigger coverage under the Act, we apply this 90-day time period, and over that 90 days, they've laid off 70 employees. If they have not provided the 60-day WARN notice to these employees, they would be potentially liable to all 70 employees for having failed to give the 60-day notice required under the statute. All right, can I have the next slide? All right, so the statute lays out the individuals and entities who need to receive notice of the layoff. For those employers in a unionized setting, we need to give notice to the chief elected union official. And we would recommend that that notice be given to the president of the local union as well as the international, just to make sure you cover your bases on that point. All right, next slide. So for non-union employees, each affected employee needs to be given the notice. And that's going to include workers who are on a temporary layoff at the time that these layoffs occur. So that's for your non-union employees. Each affected employee needs to be given notice. For the union employees, notice is essentially given to those employees by notifying the union. All right, next slide. All right, so the affected employees, as I had said, they're going to receive notice either directly or through their union representative. And because WARN does not apply only to your hourly workers, this is going to include your supervisors, your managers, and executives as well. They are all also entitled to notice if they're going to be affected by a layoff. Next slide. All right, in addition to notifying the union representative if you're a unionized employer or the affected employees directly, we are going to provide notice to local government officials, and that's going to include the State Dislocated Workers Unit. That's where I mentioned that you can go on the state's website and you can actually see copies of notices that have been provided so far. I looked this morning and there had been 61 WARN notices that had been provided as of March 24th. And just to give you an idea of, some context, over all of 2019, there were 57 WARN notices that were issued. So during this 3-week time period, since the governor's order has went into effect, we've had obviously a significant increase in the number of WARN notices being provided, even though hopefully this is going to be, a short-term interruption, not lasting longer than 6 months. and hopefully those notices aren't even required. But we give notice to the state dislocated worker unit, and then we also give notice to the chief elected official of the unit of local government. Again, this is just to cover your bases. You might want to give notice to, if you're in a municipality, the mayor or the city manager, and then even the county executive as well, just to cover your bases on that. Okay, next slide. So what's the notice going to include? We're going to include the type of action that we're taking, whether the layoff is expected to be permanent or temporary. We're also going to give notice of the expected date for the first round of separations. Next slide. We'll notify employees of the anticipated schedule for making separations if it's not going to occur all at the same time. We'll indicate whether bumping rights exist, and if bumping rights do exist, because they're either in a contract or maybe your handbook provides for them, we try to identify who is going to be the employee that's affected by those bumping rights when we provide the notices. And then we also are going to list the contact for the employer for employees who have questions. Next slide. So the notice is, as I had said, required at least 60 days in advance of each employee's separation. For determining the date of separation, it's going to be the last day of the employee works, and we're going to use calendar days and not working days. All right, next slide. So if we have to extend the time period for when the layoffs will occur, we're going to provide notice as soon as practical of the extension for the layoff date. If it's going to be postponed less than 60 days, and if the layoffs are going to be postponed out more than 60 days, we're going to provide a new notice of the layoff. So we're going to, again, provide notice to the chief union elected official if the employees are represented by a union, each employee directly if they're non-union, and then also send those notices out to the state dislocated workers unit and then the chief elected official of the unit of local government. All right, next slide. So the WARN Act does include exceptions for providing a shorter period of notice than the 60 days that's provided in the statute. One exception is the faltering company exception. Just briefly, that applies to plant closings but not mass layoffs. To fit within that exception, the employer has to be actively seeking capital or business at the time that notice would be required. There has to be a realistic opportunity that the employer would get the new capital or business. It would have needed to be sufficient to avoid the layoff, and the employer has to have a reasonable belief that having given notice to the employees would have impaired their ability to get the new financing or the new business. But I'd like to focus on the unforeseeable business circumstances exception, because under that exception, the employer can gives notice as soon as practicable once they become aware of this unforeseen business circumstance that's going to result in the layoffs. If we go to the next slide, we can kind of look at that exception a little bit more closely. So here we kind of have included the description of the unforeseeable business circumstances exception that is in the WARN Act regulations. And I just want to focus on the language here that talks about the layoffs being the result of a sudden, dramatic, or unexpected action or condition outside the employer's control. And it's hard to really think of anything that fits that better than the governor's order requiring businesses to dramatically cease operating or limit their operations. I think clearly this exception would apply. And so, if an employer has given less than 60 days notice of a layoff covered by the Act as a result of the order, I think clearly that would be covered by this unforeseeable business circumstances exception. But again, the employer needs to provide the notice as soon as practical. All right, next slide. So when a layoff is announced and it's anticipated that it's going to be less than 6 months, it will still be treated as an employment loss under the Act if the layoff ends up being extended beyond 6 months, unless the layoff was extended because of unforeseen business circumstances, in which case we're going to provide that notice as soon as practical, or notice is given at the time it becomes reasonably foreseeable that the extension is beyond 6 months is required. All right, next slide. Okay, so what happens if we fail to give the statutory notice? Employees could be entitled to damages, including back pay and benefits for the period of violation, which would be up to 60 days if no notice at all was provided. There's also attorney's fees and a civil penalty as well for violations of the Act. All right, next slide. So it's important to also check your state rules and statutes. Many states have what are called mini warn notices that apply to smaller employers. Michigan does not have a mini warn notice, but if you have employees outside of Michigan, it's also important to check those state laws as well. All right.
Great, thanks, Chris. Do we want to see if we've got a couple questions here? Let's take a look. So one question we received asked if there's an employee who has poor performance, but is also in a protected class because of their age. Should we steer clear of laying that person off? Or does the poor performance cover the risk of letting the older person go? Obviously that's going to be pretty fact specific, depending on kind of what's going on underlying that. I guess what I would say generally is that when you are coming up with your objective selection criteria, you should be able to apply that across the board. So in that instance, if one of your criteria is poor performance and you've documented that, I would think that that would help with offsetting some of the risk relating to letting that person go. But again, that would be something you'd probably want to dig into a little bit more with counsel. Let's see, we have another question related to paying for non-worked hours based on employee personal risk assessment. If we reduce staff going forward, is a decision to stop paying for that time going to have a disparate impact? And could we use that information in determining a reduction in force, or would that be adverse? I guess my thought on that would be if you're not paying, if you make the blanket decision moving forward for all employees that you're not going to continue to pay for non-work hours, and that's applied uniformly, I wouldn't see that as having a necessarily disparate impact. I guess I don't know enough about what's underlying that, but I would think that if you apply a decision consistently across the board related to that pay, that you would have a good non-discriminatory business reason to explain why there is that pay reduction. Chris, I don't know if you have any other ideas on that one.
Yeah, I mean, I don't know. I think you're gonna, look at all the other factors that you've already talked about. Is there a legitimate non-discriminatory reason for the action that you're taking? I think it's the same analysis that you would engage in for any other, potentially adverse action that you're going to be taking against an employee.
Yep, I agree. Let's see here. And it looks like there's another question related to reducing salary for exempt employees. And the question is, can we? Can we reduce salary for exempt employees? My response to that would be, obviously with the FLSA, we can't reduce for exempt employees based on quality or quantity of work, right? So if you are on a weekly basis or bi-weekly basis adjusting that exempt employee salary, then you could run afoul of the FLSA and there could be a finding that that person was classified as exempt improperly. However, if you, as a cost-saving measure in this environment, decide that you are going to implement a reduction in salary moving forward, maybe it's a 10% reduction, whatever it might be, and that's the new salary, then generally speaking, yes, you can do that. Now, you want to be careful implementing that, and you also need to take a look at whether those individuals who will be impacted have an employment contract or there's something else in play there that would prohibit you from making that reduction. But many companies have done that as a cost-saving measure, and it's certainly something that you can consider. And with that, I don't see any additional questions at this point. Chris, do you have any final thoughts before we sign off?
No, I mean, just thinking of that first question about making a reduction based on performance when you have somebody who's in a protected classification, again, hopefully you've documented what the performance concerns are, but I think it's the same issue regardless of whether you're talking about a reduction in force. Is anytime you're going to terminate an employee who falls within that type of protected category, you just have to make sure that you have documented your legitimate business reason and can support that action. So I think it's the same analysis in a RIF. But I always like to say that for example, the ADEA does not provide people super seniority that protects them from those type of actions. But again, hopefully you just have the documentation to back it up.
Yeah, I think those are great reminders, great points. I think with that, not seeing any additional questions and drawing close to 11 o'clock, we're going to wrap it up. Thank you so much for joining us. And please stay tuned. There'll be additional webinars tomorrow. Thanks so much.
Yep, thanks, everyone.